Everybody. Thanks for joining us for Minnesota Matters. I'm Tess Rice, MBA's General Counsel. As usual, I'm joined by Teresa Kuvas, our Senior Government Relations Manager. She's going to start us off talking about the end of the regular session. And then Tom's our Associate Counsel and Compliance Consultant. We're going to talk about powers of attorney. So if you have questions for us on that issue or really anything else, please put them in the chat. This will be recorded if you want to watch it again later. It's on our YouTube channel. That's it. Thanks, Teresa. Let's start with the session.
Sounds great. Is my microphone working?
Yes.
Perfect. Thank you. Good morning, everyone. The end of the legislative session, regular session, ended on Monday. The House adjourned around midnight. The Senate adjourned around 10 p.m. A lot of, not disarray like last year, but still a lot of uncertainty kind of as to how the next couple of weeks will look. Just to kind of really rewind and look back at the beginning of session, I look at sessions and I'm able to erase a lot of the stuff that happens at the beginning. It's kind of how you get through a 5-month session, and kind of, if you really look back at kind of how session really began, it was really kind of chaotic at the beginning when there was really no clear majority in the House, and there still isn't, because we're at a 67-67 tie in the Minnesota House. But there were a couple special elections that were happening. There was the Shakopee seat that was kind of in the courts, and were they going to seat Brad Tabke. So if you really look at those first 5 weeks of session, really nothing happened until the beginning of February. The Democrats hadn't shown up. The Republicans were holding hearings. It went to the Supreme Court. And it feels like such a lifetime ago when you really kind of think about how far we've come. But also kind of looking at session, you started the Senate with a 33-33 tie because Senator Dietzig had passed away right before the beginning of the year. There was a special election in that area. So that went back to 34-33, but we were still sitting, we were not at full strength in the Minnesota legislature till 2 weeks ago. There was that other special election up in the Brainerd area. So again, a lot of kind of people coming in, people coming out, what was a majority, what wasn't a majority, 67-67 in the House. So everything really needed to pass kind of bipartisan. And so if you really look at Minnesota, we have 101 Democrats and 100 Republicans. So where we sit today, coming out of the legislative session with we got a handful of omnibus bills done, but still not the big ones. It's not unusual. You have a lot of people that talk about special sessions and just kind of disarray, and they can't get their work done. Had the Democrats showed up at the beginning, we wouldn't be in this mess. We would. Realistically, we're going to be in a special session when we have divided government. It takes deadlines. It takes true deadlines. You have the constitutional adjournment deadline that really kind of isn't really truly the deadline. The deadline is June 30th. July 1st is when a government shutdown would start. So that is truly the deadline as to when the legislature has to have their stuff done. That being said, last week, about a week ago today, the governor and the legislative leaders came out with we have a global targets, because that's really where they have to start with, is they had to have numbers that they all agree to and how to get there. That allowed for a handful of bills to get passed over the weekend. We watched the housing bill get passed, the agriculture bill get passed. We watched the judiciary, public safety, finance bill get passed. A cannabis bill got passed. Housing, agriculture, judiciary, those are all ones that we do closely watch. We do have items in there that we will be reporting on in our legislative summary. There's still, we are 15 years past the financial crisis, but we are still dealing with foreclosure legislation. And there was some of that in those judiciary bills as well. So there's a handful of those things that were in some of those bills. So we will be reporting on those. So there was a handful of bills that did end up passing before the end of session. The one that we truly, there's two obviously that we really, really watch: commerce and taxes. The commerce bill, if you really looked between the House and the Senate commerce omnibus bills that passed off of their respective floors, there were a lot of provisions and even a lot of the numbers that matched up. So we truly believe that commerce bill, even though they never had a conference committee, that commerce bill could have gotten done before the end of session. It didn't. The rumor was that because that also includes reinsurance, and that was kind of what the holdup was. Fingers crossed, we are hearing that that bill is done. We heard that there possibly could be a meeting today. I've not seen it posted yet. But there's a handful of provisions that the MBA has been working on, which again will be reported in the legislative summary and test and touch on them a little bit if we want to, on the safe deposit box renewal, and a couple other closing of accounts and stuff. So that one we truly believe will end up getting done in the next couple of days, kind of wrapped up before they call a special session. The other bill that we truly kind of have been, we've reached out to a lot of you on this call. We've had a lot of phone calls into legislators, was on the tax bill. If you recall, the governor and Commissioner Marquardt at the Department of Revenue looked at decreasing the sales tax in general, not very much, but expanding it to professional services and fees. And so that would have pulled in attorneys, CPAs, banks. And so it was supposed to be a wealth tax. But when we really kind of had the conversations, it was going to hit everything. It was going to hit your maintenance fees. It was going to hit unless it was specifically exempted out, overdrafts, late fees, it was going to be taxed. And so we really talked to the chairs. We talked to, we actually sat down with the Department of Revenue. We had a lot of bankers really calling the blue dog Democrats in the Senate that were on the Senate Tax Committee. And that was one that we worked really, really hard. And knowing that the Republicans really didn't want to increase taxes. But once those tax bills were finally released, neither of them had that language in there. And the bigger question was going to be the Senate, because we believe that any tax increases were definitely going to come from the Senate, because with a 67-67 tie, you had to get the Republicans on board as well. So the fact that it was not in the Senate, I really do believe that, the calls that we have made to the legislators that were on those tax committees, because we really focused on, it's harder to vote against a bill if it's included in there. So the goal was really to make sure that that language was never included in the first place. And so we had some bankers that really made those calls and had received information that those provisions would not be in there. And then last week, when the governor and legislative leaders had their press conference, the governor made comments about the sales tax and that it had been compromised out. So the language was not included and hasn't been discussed in any of these bills. Another couple of things that one thing I think is a big win for Minnesota, Tess and I have been on calls with, all the 50 states, and every state. In Illinois, there was a bill that passed last year on interchange, that you couldn't charge interchange on sales tax and gratuities, I believe. And so that has kind of gone through the courts. It's been passing in every other state, or actually it's not been passing, it's been introduced in every other state. So one thing is that it was never introduced here, knock on wood. It could obviously be introduced in the next couple of weeks with a special session, but it has not been introduced here. And we believe that I think it's been introduced to a lot of places because they obviously want to push it to a congressional vote, which could possibly happen next Monday. And, we can get information out on that being added, that being discussed in a bill in Congress. But other things that we dealt with this year were, the hearings on a possible, on the Consumer Financial Protection Bureau and what's happening in DC and how that's going to impact the state. So we watched, AG Ellison testify on the importance of the CFPB. So a lot of that stuff that happened this year. But, we don't have as much to report on right now, as we're still watching what's happening in St. Paul and kind of what their timeline is. But again, as I said, the drop deadline is June 30th. That's when they have to get everything done. The goal was that they're trying to get everything wrapped up this week. The tax committee working group has been meeting in the last couple of days. They met last night at 10 o'clock last night. And it's, you see Chair Davids, who is very frustrated because they can't agree on the small things. So how are they going to get to the big things? And do you send this over to leaders? And do the legislative leaders, are they the ones that are making the tax policy? Which is definitely not what they want to do. But June 1st is a very important date. If the legislature has not passed their bills by June 1st, that's when the furlough layoff notices start. They have to start looking at a government shutdown a month before the government would shut down. So that's when those notices will possibly start going out. So the goal is that they can wrap things up internally in the next couple of days. The governor could possibly call a special session, mid next week, do a 1-day session to pass all of these bills. And then kind of get them moving so that we don't get to the point. But I feel that things are starting to move, not as much in the public, which I think is what a lot of people get really frustrated with, the lack of transparency. But things are happening and people are wandering around the Capitol, but not getting as much information as we possibly would like. But again, we'll send another political insight once we do know more, and then watch for the legislative summary as soon as everything does kind of finalize. But Tess, is there any of the specifics on any of the issues? But that's my update at this point.
Yeah, Teresa, wasn't there a bill to create a state level CFPB?
Yes. So in the last 2 or 3 weeks, it was one of the Democrats, actually a handful of them, all introduced, and I have not seen it introduced in the Senate, but for a Minnesota CFPB. But since we're flush with cash and we have no problem figuring out the budget, I'm sure they could, we definitely have the resources to just add another
Agency,
in
yeah.
the state. So if anybody's looking
Yeah,
for a job,
and it's a little hurtful.
there's a possible job there waiting for you.
Yeah, right. I thought it kind of hurt the Department of Commerce's feelings. I mean, they consider themselves the protector of consumers, and I don't know, this implies they're not doing their job. But anyway, we didn't really have to worry about that. As Teresa said, there's no money for that kind of thing. So that wasn't a big concern. But I think overall, what you're saying is this was a pretty good result for banks so far. I mean, that divided government is key, of course, but to not have that sales tax, that was our priority issue. And then we have 3 provisions in the Commerce Bill that we expect will pass. And the only one I'll mention is that you'll be able to close accounts without giving that 30-day notice that's required by statute if you have a customer that's harassing bank employees or other customers. That definition of harassment comes from criminal law, and it's very broad. It encompasses just about every kind of activity you could think of. So anyway, we've heard from a lot of bankers that they have customers that are disruptive and they really just don't want them back on the premises. And that's hard to do, to trespass someone when they have an account with you. And so the idea was to get these accounts closed immediately, send the notice that same day, and then you can keep them from being on your property. So we're excited about that one. And the rest of it is kind of fixes from last session and not super interesting, but overall, I think we had a really good session.
No, and I agree. And, and I will say, the Republicans having that 67-67 tie in the House, they definitely wanted to come back and try and clean up a lot of the stuff. And that's why we were seeing this, a lot of pushback, on some of the unemployment insurance in the school area, for seasonal workers. Then you're also looking at the undocumented healthcare, paid family medical leave. The Republicans are trying to push back because they definitely didn't have a say in the last couple of years, and really to kind of have that, even that tie is, trying to get small incremental changes. So we weren't going to get, sweeping reforms and undoing what was done the last couple of years. It was really slowing things down. And I think, and we've had conversations, as you watched last week when they discussed the undocumented healthcare, and you had press conferences where the Democrats were like, well, we would, why get rid of it? We could just tax more. And one thing I think that's really important to also look at kind of as this session, we had great relationships with all 3 of the Commerce chairs. A lot of them, they would all reach out, even on kind of that harassment. The chair didn't like the language that was originally in there. We kind of worked with them, and they worked with us, and we were able to get it to the point where they were happy with it. That's the language that we would assume that's going to be in the final bill. But one thing to really, really kind of really notice is if you look at the House Democrats, I think 60 to 70% of them have never been in the minority. So they are very used to getting what they want. And what we're starting to see is, is just kind of that, we will just do what we want, and just kind of like, as I kind of reference it as to kind of, you saw last week when the governor was having his press conference, there was knocking on the doors and screaming outside because some of the legislators weren't happy with the compromises that were going to have to be made. So you have a handful of Democrats that have never been in the minority, have never had to compromise. And you have a lot of Republicans that have never been in the majority. And so they also don't know how to, again, it's a different kind of compromise. So it's just been a very unique, and again, and the state office building being closed where they're all in the Centennial, it's been a very different dynamic this year. So, but it's been interesting and it's been good for us. And so it's been, I will always say I will take divided government over one party control any day of the week. So.
Did the need for the 30-day notice to close an account go away for harassment of employees, or is that still to be passed? So yeah, that hasn't passed yet, but we expect that it will.
Just wait. And that's the one thing is I think as long as there's agreements on policy, and that's where I think right now with some of the other bills, is that they're getting tied up in policy, and then the financial side of things is what needs to get fixed in a lot of the other bills. And so a lot of policy will go away in some of the other bills. So I have not heard from the commerce chairs that our policy isn't included. So at this point, again, because everything matched up, I suspect that it will be in there. So that is my report.
And the Commerce Department carried that language for us. So it was in their bill, and that's, usually a bipartisan supported bill. So that was very nice for us to have that in their language. So we weren't pushing a standalone bill on this. So yeah, we do expect it to pass. We will let Teresa go. She's got more capital biz to take care of. So
Sounds good. Thank you, everybody.
Okay, thanks, Teresa. Okay, so Tom and I want to talk about powers of attorney. We've had so many questions lately.
All right.
We both, I
we
think,
go.
have brought up some questions here. But I've got some really good ones, Tom, that come up all the time. Hopefully we don't have the same ones.
Yeah.
It may be that
Yeah,
we have
that's
the
right.
exact same ones. But
Yep.
this one just
It could-
came
it
up.
could be.
So 4 years as a banker, we were told that unless a power of attorney document explicitly allows the power of attorney to act as trustee, we could not do it. So they have a customer who has a trust checking account, and so he's the trustee, and there are successor trustees listed, but he wanted to use his power of attorney to make his children signers on that account. So it's a trust account. He's the trustee. He wants to use the power of attorney to make his children signers on that account. So one thing that is really important, the statute lays out a lot about power of attorney, but not everything, right? You can look at the power of attorney statutory short form, and there's a lot of information there too. But a lot of times the statute doesn't really answer the question. But I think in this case that it does, because if you look at the power of attorney statute, the part on fiduciary transactions, it says that nothing in this subdivision authorizes delegation of any power of a fiduciary. So the trustee is the fiduciary, unless the power is one the fiduciary is authorized to delegate under the terms of the instrument. So the trust agreement. So the trust document has to say that the trustee can delegate their powers. Otherwise, they can't do it. And there are lawyers that will argue this point, but the statute's very clear. And then we have a Court of Appeals case in Minnesota, Wells Fargo was involved in, where the court found that the trustee could not delegate the powers because the trust document itself didn't permit it. So that's a question we get a lot.
Right. So the big thing there is you need both documents to determine whether or not they can or can't in that situation. So that's getting more information. And sometimes if you just have a certificate of trust, it may not address that. So, and if they don't want to share the trust document, then you can't verify it, and you'd have to not permit that kind of activity.
Yeah, that's a good point. What do you think, Tom, about the idea that in order to delegate fiduciary responsibility through a power of attorney, that the power of attorney document should be signed as trustee? There's some experts that think that you would sign that power of attorney document as Tom Boswell Healy, trustee for the Boswell Healy Trust.
Yeah, that's an issue. That's what I don't think I've seen that question before. But I don't know. It's I think the power of attorney is a personal power that you're granting to the person, not a role. I
Yeah.
don't know how helpful that would be signing as the trustee for something. Because then are
I
they
think it
trying to give
adds a
the power
layer
of
of,
attorney to the trust
yeah.
then? So then any trustee could sign for the, I don't, yeah, that's kind of how I would think. But I would think it's a personal authority you're granting to the individual rather than the trust. So I don't see
Yeah.
what the trustee signing as a trustee, I don't see what that gets you. But if you can get a court to agree, I guess that's
Well, that's really the issue, isn't it? I haven't seen a court case on this, and so I don't know. I mean, I don't think you could require it because I don't know what good reason you would have to say, oh, you need to sign this. The principal needs to sign as trustee. Okay, here's another one, Tom. This one comes
Yes.
up all the time.
we
Can a
did have a
person with
question
power?
we did have a
What?
question from Joe on that about if
Oh,
there's
okay.
magic trust language for delegation to a POA or generic delegation provision acceptable. I mean, I think you definitely want something delegating the power to grant a POA, specifying that. I don't think it depends on how general that delegation language is. If it just says they can do anything the principal could, or the grantor can do, I don't know.
Yeah, but what if it was, the terminology was agent, or, you can delegate
Yeah.
your duties to an agent? I don't know. I mean, Joe, we haven't seen a court case on that. It obviously preferable if it said power of attorney.
Yeah.
Yeah.
Yeah, because an agent is more general thing, and it could, than the power of attorney. That's that attorney in fact relationship.
Yeah. Okay, this is one we get all the time. Can a person with power of attorney add themselves as owner to an account?
Potentially they can. It depends on what the power of attorney says. So that would be considered a gift. So they'd have to be granted gift transactions, and they specifically, if they're using the statutory short form, they'd have to grant to the attorney in fact the ability to give gifts to themselves. So that's on the statutory short form towards the end, a separate section. So if they
What
don't have that
if
marked, or they specifically have it marked that they can't, then they can't do that.
yeah, but what if the account has $100,000 in it? And you've got the gifting limitations in the Internal Revenue Code,
As far
right?
as what sort of tax implications there are.
Well, I don't think they have the authority to gift more than that gifting limit, and are they gifting then to themselves more than that limit? Again, no court case on this issue.
Yeah, no, nothing on that. I mean, I don't know well, I don't think it should be the bank's responsibility to enforce that kind of IRS limitation on the gifting. I mean, the POA should have the documentation, and it would be up to them to handle the estate impacts of doing that. I mean, they could certainly do it to make it easier to administrate the estate. That could be a reason, since the power of attorney, when somebody dies, the power of attorney is over. So they could be doing that as a reason to make it easier to administrate the estate upon death. But they'd have to have accounting to show, if it were to come up in some sort of audit, or even just a suit between other beneficiaries of the estate
Yeah.
as to what's.
I mean, the issue is if there's some breach of fiduciary duty, right, that we're seeing potentially, that's what a bank wants to avoid,
Right.
if you know that there's a breach occurring, that's where liability can be created, where the beneficiaries could go after a bank because they didn't protect the trust assets from this obvious breach of fiduciary duty by a trustee. But haven't seen that court case either.
Yep. Yeah.
These are just
All
things we
the
worry about. I know you
all the
worry
fun
about
stuff.
too.
Yes. Yeah, it's concerning. I mean, the banks are kind of put in a position where they have to be uh, the bad cop for some of these things just to protect themselves, and but it also is protecting the other beneficiaries to those funds as well.
Right. Yeah, and that brings up the point that I think we usually recommend that a bank doesn't get the trust document. Maybe you get the
Right.
title page, but it's better to operate with the certificate of trust form only, because then knowledge of what's in that trust isn't really imputed to the bank, right? Because
Right.
you haven't seen the language, so they can't say, well, you knew this provision was in there. You have a copy of the trust and you allowed the trustee to do more than they were allowed, or something like that, right? So if you just have the certificate of trust form, then you avoid that.
Yes, and yeah, and it's the certificate of trust may not outline everything that's in the trust, obviously, just what's pertinent to whatever transaction they produced it for.
Yeah,
So for
and it'll
banking
be that you know who to
transactions,
deal with. Yeah,
right?
you know who the trustee is. Okay, this is my third one, and it has to do with a power of attorney and then a business account. So, sometimes, well, I'll just read the question. I have a customer that has supplied us with POA paperwork. The form issued is a statutory short form. He has marked all powers. The customer had a business account. He is a partner in the business, but the only signer on the business account. Would the POA cover his signing authority on the business account as well?
Yeah, ostensibly it would, unless you've got some sort of, kind of all in the POA. If you've got some sort of actual information otherwise that would contradict it, or if there's a dispute with the business. So in that situation, they're a partner. So if there's another partner that's not listed as authorized signer, but that other partner has contacted the bank and said, hey, you know, we're having a dispute, then it might be, I think it would be prudent then to put a pause on it and say, you parties figure out what's going on with the ownership of the business, and then come back to the bank, and then we'll enact whatever's has been decided. But I mean, that comes up in other different types of accounts too, where I've seen charitable accounts where there were two competing boards for the charity. They both wanted access to the accounts, and the bank was saying, "You two have to figure out who is the properly, authorized board to act and to grant authority to act on the banking accounts, because it's not the bank responsibility to mediate your dispute. You have to figure out who's the proper authority over the account, and then the bank will permit those individuals to transact business. But yeah, I think
I think
the
we're about to have a dispute on this, because are you
okay.
saying that a personal power of attorney authorizes someone to act on behalf of a business entity?
Well, authorize them to act on behalf of the principal. So not necessarily the business entity, but if the principal has some, authority, and they can step in the shoes of the principal in those sort of business transactions.
Okay, so yeah, I don't think we're on the same page there.
All
So
right.
let's say I am an authorized signer on MBA's accounts. I've given my power of attorney to my husband. He's not going to be able to come in here and transact business on behalf of the
No,
MBA.
no. Yes, I certainly agree with that. Yeah.
So I think that
But
the
it's,
entity itself has to have a new resolution. I mean, that's the proper way to have someone sign on behalf of a business.
I just, in the partner in particular, I think that you may have some
Yeah.
gray area there, since every partner can act. And if the partner granted an attorney in fact all their powers, including their business powers, then I think they may be able to act in lieu of the partner principal.
Yeah, I think an informal partnership in particular would be um, a little more tricky. I mean, if you had a formal partnership and there's a partnership agreement that spells, you've got a
Yeah,
resolution from the
it should cover all
partnership.
that, and it shouldn't, yeah, the
Yeah,
POA shouldn't matter in that case, right?
yeah, yeah. Okay, those were my top three, Tom. What do you have?
Okay. One that I get quite frequently is about foreign POAs, both from another state, but also it could be from another country. Obviously, it's another country and another language. That's a different kind of burden. But under Minnesota statutes, it's whether it's as long as it's validly executed and the jurisdiction in which it's created, then it's valid in Minnesota as well. Now, the bank doesn't really have any method to determine if say a POA executed in Hawaii was validly executed, but there you kind of rely on, um, the presentation of information, and there's nothing in the document that looks like it's untoward. You have no notice of any sort of dispute, anything like that, and you can rely on those foreign POA documents. And we
Agreed.
had
Yeah.
we had one that was brought up um, too about old statutory or not necessarily statutory forms, but old POAs and whether those are valid. And going through those, it looks like, ostensibly they would be valid, um, but looks like there's some extra protection there for banks because it may not be covered by, or it may not, there may not be necessarily be liability if you reject it because it may not hit the standards for what triggers the liability. In those, just had a couple notes on the liability. So the big thing, you have to hit a few different things. You could use the statutory short form or the alternative, which is a military POA form. If it's using on that, and it contains the attorney in fact specimen, signature specimen, that is, if it's after the certain date, it contains a statement that the attorney in fact notice that's in the statutory short form has been read and understood. So it's kind of got all these sort of things that hits in liability. So an older form may not hit all those standards. So the bank may not incur a liability. So it could be something where the bank says, get an updated form. Um, so they know that it's still complete, but kind of ostensibly it can be, there's no end date for the POA necessarily unless it specifically includes an expiration date.
Yeah. Yeah. And we did have some feedback from the Bar Association many years ago about banks refusing powers of attorney, and there is liability for that.
Yeah, yeah, that can be.
Especially if they're coming to you with a statutory short form. That's an easy
Right.
one. I mean, you've got to accept it as long as it's completed, right? You
Yeah.
need to accept it.
Yeah,
Unless there's something that you shouldn't.
right.
Yeah, we had one a couple of weeks ago, somebody asked about a situation where they knew their customer didn't have capacity to
Right.
sign this, right? He
Yeah.
was in a memory care facility and was not close to his family. And then the family stepped in when he was in that facility, went to a lawyer with him, and the first lawyer said, no, I'm not gonna help you with a power of attorney. He doesn't have capacity, but the second lawyer did. And
Yeah.
so, that's a bad situation where the bank is dealing with probably an invalid power of attorney form. And, there was someone else who was this person's heir and had a power of attorney form. So, I mentioned that to one banker and she said, in that situation, her bank has done an interpleader action, meaning you turn the
Oh,
money over to the court and you say,
yeah.
you know what,
Yep. Step away.
we have this situation, we don't know what to do with it. And someone, the court's gonna have to decide this.
Yeah, there
We
certainly
got
could
it.
be oh, yeah.
No, go ahead.
Oh, it just on that as far as the not having capacity and then you don't have a valid POA. I think it'd also be something you consider, if it's a older person, you could certainly report that to Mark and through the Department of Commerce. There may be, a vulnerable adult exploitation occurring as well. So,
Yeah, there is some new legislation this year. I think it's in the Judiciary Omnibus Bill, and I think it will pass. And it's a new type of order where vulnerable adult fraud is suspected, where families will be able to act very swiftly to stop it. So we'll make sure to get all the details of that out if that passes in our legislative summary. We have a question. A customer was told to put their LLC business under their trust. Would this basically be transferring interest in the business from the individual to the trust? What documentation would we need for the business account to change ownership?
I mean, it's simply, I think it's, essentially a sale, whether there's, specifically any kind of consideration going on or not, and if they're doing it just for tax related purposes, but there should be some documentation indicating the change of ownership. There's a few different documents that they can do that, that'll sort of have the same effectiveness as like a quit claim in real estate.
Yeah.
It's just a short little document saying, you know, this entity is giving up all its rights and interests, obligations, and the entity to, whatever the other party is. But you could
So
certainly, yeah, I
then,
mean, a trust could own multiple
mhm,
entities if they wanted to. That's,
but it's still an LLC account,
yeah,
and there'll be a resolution, I suppose, saying
yeah,
who the signer is, right? I mean, in that sense, it's
yeah,
the same.
yeah, and that may not change. It would just be the ownership.
Yeah,
They could have the
yeah.
same authorized signer. Everything else could remain the same. Just the ownership would change.
We had a comment from Jennifer. Thank you for that. Marty Fleischacker at the Department of Commerce
Yep.
is now retired. Boima is the one I speak to now. He's excellent. Yeah, I've talked to him too. So
Yep.
that is a
Would
relief
is it
because Marty,
Friedman or
he was great, and we were concerned, what's going to happen now. But yeah, he's very engaged. So that's great.
yes, I've talked to him a few times myself as well. So
Oh, have you?
he reaches out when he had because he was asking me a question. I don't even remember what it was, but he was asking me a question about something. I just think about how banks function. I think it was, but
Okay.
so that's good.
Does anyone have, Boima's contact information? I think I
I
do, but.
I do. Maybe not right at hand, but
Well, if
we
you
could
want to
probably
talk about something you have, I'll look it up,
you could probably
see
set
if I
that
can
up.
find it.
Let's see. As what other questions? We frequently get questions too about competing POAs. Like, we have a POA that's signed to an attorney. In fact, oftentimes it's familial. So maybe the father has a POA that grants to a daughter, and then has another separate POA that they don't mention each other, that's given to his son, and which one is effective. And again, there the as long as each POA is validly executed, so you don't have any actual knowledge that either the person didn't have capacity to execute the form or something along those lines. Each one is valid, and you can have multiple POAs. I mean, it's certainly more normal if you're going to have multiple POAs to have those you can put those in the same document. If they're claiming that the other POA, usually it's one that was created prior, let's say that this is the real POA, the earlier POA isn't effective. Well, there's a mechanism where you can revoke a POA, but that has to be done in a written document. So unless they have that written document, that existing, those, whatever POA was pre-existing is still out there and valid. So that comes up on occasion too, and it's always a pain for the bank. So
Yeah, it really is. What do you think about calling a customer or the principal, if they still have capacity?
yeah, you could
Saying,
that would be a way to get some actual knowledge, certainly, if they have that, and it could be just some confusion. They may think that, well, the subsequent POA that invalidates the prior one, which is not the case. And if they want to revoke any POA, there's certain steps, statutory steps they have to follow to do so. including it has to be a written document. The principal has to sign it and all this good stuff as well. So if they do that, and then they have to present it to people so people are aware that there's a revocation out there. Otherwise, the POAs, go on forever. That's another question too, to make sure you know the difference between durable and non-durable POAs. Um, and they terminate essentially exactly the same. Obviously, the principal dies, the POA goes away. If there's a stated expiration date on the POA, it goes away. If it's a spousal POA, then as soon as you start proceedings to dissolve or separate or annul the marriage, then the spousal POA terminates. And then for the non-durable one, um, it also ends as soon as the principal lacks capacity or is incompetent. So, and that should be some sort of formal. There we go. Tess just put in the chat Boyma's contact information, number, and email. So yeah.
Found it.
Yes.
Um,
Good.
Did you address this question from Kimberly? It's the multiple.
Oh, it was Kimberly. Oh, there we go. Let's scroll up there. Emailing yesterday multiple POAs. Nope. Yeah, and that's what I was just thinking. It doesn't, a subsequent POA doesn't invalidate a prior POA. If they want to do
Right.
that, they have to do the formal revocation of the POA, and that's probably something where Tess was mentioning calling the principal if the principal is available and you can contact, because they may be under the mistaken impression that if you execute another one, it just wipes everything out before it, but that doesn't happen. So it may be a way to educate your customer.
Well, what do you think
How
about the idea that a bank could require, we've got a power of attorney account already. You already gave this to us, and now there's this other person coming in. We need you to decide who's going to be on this account. We don't want to
Right.
deal with people not on our accounts. Do you know what I mean?
Yeah, certainly, as long as it's not a situation where the principal lacks capacity that you know about or anything, you can certainly contact them, because they're all getting their authority through the principal. So the principal would kind of trump that if they don't want a particular one, but they need to follow what the requirements are. And, if they have something that, don't the principal saying, don't accept this POA, but accept the other one. At the very least, you'd want to get something in writing signed by the principal saying that, even if it doesn't hit the formal requirements of a written revocation. But I wouldn't rely just on a post-it note. Joe called in and said,
Yeah.
don't let this person act as my attorney in fact.
Yeah. Okay, here's another question. When we are presented with the power of attorney form at the bank, is it appropriate to get a copy of the power of attorney form? So does the bank take its own copy? I have personally encountered a bank that would not take a copy and required the power of attorney form presented each time an instance came up where the power of attorney needed to make any changes. How are we to know if we are being shown the latest version of the POA papers?
Yeah, and there's no way to know on that. You are protected and liability if as long as the attorney in fact is signing, they're presumed to be acting on behalf of the principal in an appropriate manner. As long as they sign, and they're supposed to sign in certain forms, so that it's indicative of what the relationship is with the principal, that there's a power of attorney going in there. But yeah, there's no way to know if there's any subsequent changes to that. And as I said, there's those prior POAs, they just kind of hang out there until they're formally revoked there. But yeah, I think it may just be the bank's comfort and what sort of documentation they're willing to retain and be responsible for having the knowledge of what's in the document. Like Tess was saying about the trust agreements, lots of banks don't want to retain the full trust agreement because they don't want to, you know, have that sort of imputed knowledge of everything in the trust agreement. It could be a similar thinking with the POA as well.
I don't think that's unreasonable to require the form when when a attorney in fact wants to do something to the account. I mean,
Yeah, if there's something different,
yeah,
it's a POA that's been in place for a few years and said, okay, now we're going to do this. It's like, okay, well, what changed? I think that's a reasonable response.
yeah, yeah. I mean, if they're named as the attorney in fact on an account, obviously most of the time the account's going to operate without any forms being needed. But yeah, if there's some big change, I don't know what that would be, but I don't think it's unreasonable to ask to see it again.
Yeah, certainly if there's a successor trustee or something like that, you'd want to see them
Yeah, yeah, that's a good example. Yeah,
identified, but that would be a different attorney in fact then, not the same attorney in
yeah,
fact.
yeah. But there could be a successor attorney in fact
Yeah,
as well.
yeah. Yeah, they could be named in the POA or it could be named outside. So
Mhm.
it gets tricky, the POAs.
Yeah, they really are, and we're happy to take your questions. We get a lot of emails on those, and we can't give legal advice, but we can speak generally about it. But I think it's good to have that base understanding that the statute doesn't cover it all. And there really hasn't been as many court cases as one might expect on this because it usually is families fighting over money and you would think there'd be more, but I think it doesn't get to a level that we see it, they settle or they don't generally get to the appellate courts like this one case did.
All
Um,
right.
but I
Yeah,
think we do have some information about powers of attorney in the deposit manual as well. So that's
right.
also a resource to look at when you have questions.
Yeah,
Well, we
another
don't have
like
any more. Go ahead.
yeah. Oh, I was just saying quickly, another little question I get all the time is just how to title the account. That
Oh, okay.
really just any way to if it's going to be a specifically POA titled account, you just want to make sure that relationship is identified in the title of the account, and that's in the deposit manual as well. Some options on titling.
Yeah, I suppose it could be the attorney in fact's name as attorney in fact,
Yeah,
or it could
yeah,
be power of
in different
attorney.
orders,
Yeah, with the principal
Mhm.
first or something. I don't know.
Right.
Yeah. Doesn't really matter, I think, as long as it's clear
Yep.
who the attorney of fact is and who's entitled to act.
Right.
All right. Do you have any more, Tom?
Nope. That was it. I think I'm good.
Okay. So we are here for you if you have questions. We have our legal inbox, legal@minbankers.com. Tom and I monitor that. So happy to get any questions. Also, if you could use that if you wanted to suggest any topics for our next Minnesota Matters, that would be good too. Maybe we could do trust. There seems to be a lot of overlap there, but we'll
Yes.
see.
Yeah.
We'll see if
Could be.
anyone suggests anything. Thank you for joining us this morning. Oh, I got one more thing. Are you okay? The email is legal@minbankers.com, MINN bankers with an S.com. And then are you saying that anytime we receive a POA, we should retitle that account? That's an interesting thing. No, I mean, unless they're asking to do it, I suppose you wouldn't, right?
Yes. Sometimes they will request that to be set up as a specifically power of attorney account rather than it's just, you know, Jane Doe's personal account. But you don't have to have a POA in the title of account when they're using a power of attorney. But
Yeah, I agree. Okay. Well, I think that's it now. Thank you so much for joining us. Have a great rest of your day. Bye.